Hi, this video shows Darrell Brooks trying to introduce some surprise pictures to a witness, which is his girlfriend, and she may have personal knowledge of the pictures, but these pictures have not been cleared by the prosecutor and the judge, and so they have told him he cannot introduce those pictures into the court. And let's see how this goes.
That doesn't answer my question a little bit. Where did you meet the alleged defendant?
Reno, Nevada.
How long have you known the alleged defendant?
16 years.
You made reference to meeting in Nevada. Do you recall where you met at in Nevada?
No. I remember.
In relation to the alleged incident on November 21st of 2021, would it be fair to say that there's been no contact between you and the alleged defendant?
Not since then, no.
That last answer was kind of low. Did you say no?
I said no, not since then.
So that would mean, assuming that would mean no contact at all via phone or anything like that.
No.
So my question would be, I don't know if you can see them from here, but do you recognize these pictures?
You need to show those to the state. The bails will take them. It's not proper procedure, sir.
I'm going to object to those being shown to the witness. They have no relevance whatsoever to this trial.
Yes, they do. And I'll get to how they have relevance.
They've also never been disclosed to the state before this moment.
Sustained.
Sustain what?
Not relevant.
They are relevant. It creates foundation. And I can prove that.
I'll take up the issue outside the presence of the jury at the conclusion of this witness, and if need be, bring the witness back in. But next question, please.
And these need to be offered into evidence as well. You stated that there's been no contact. How would the alleged defendant be? How would the alleged defendant obtain photographs from you if there's been no contact?
Objection.
Grounds.
Assumes fact, not evidence.
Grounds.
Sustained. Assumes facts not in evidence. Not relevant.
How is it not relevant? photos just don't pop up out of the blue.
Mr. Brooks assumes facts not in evidence,
You know,
and
it's
this
facts. I
point
got the pictures right
conduct
here.
after
Facts.
the alleged date of violation here is not relevant.
Alleged violation.
You're
For the record.
correct. After the date charged, the dates that are charged for these allegations, you are absolutely correct.
Thank you. Have you, since the evening of November 21st of 2021, have you attempted to contact the alleged defendant?
Objection.
Grounds.
Relevance.
Grounds.
I'm going to excuse the jury. I'll rise for the jury. Thank you. Be seated.
Your Honor, I find it.
Hold on. All right, sir, I'm going to let you make an offer of proof as to why you believe the photographs and the questioning about contact after the alleged incident is relevant.
It's relevant because these were sent by the witness.
It assumes a fact, not an evidence, but
You
what
want
is,
the letter too?
hold on. Tell me the basis you believe there's been communication and why you believe it's relevant to
It's
her testimony.
It's relevant because it was testified to her first time testifying, and then also by was the last guy, Guth, that he was told that the witness was supposed to be so deeply afraid of me and all this type of stuff. So if you're so deeply afraid and worried about somebody and this and that, why would you
Sir,
speak
do
and have
you want to
contact?
open up the door to the other acts evidence of
That's
you
not
used-
opening.
No.
That's not
Hear me
opening
out.
the door.
Hear me out. Oh, yes, it does.
No, it doesn't.
These witnesses have been incredibly careful to abide by my rulings. Sometimes in a court of law, when there are pretrial rulings, the testimony of a witness needs to be said in such a way not to run afoul of that. This witness, Detective Guth, I believe Detective Casey and others, Corey Runkle, and even Nicholas Kirby yesterday, this court has all had to stop them so that they didn't run afoul, or they've stopped themselves so that they didn't run afoul of the court's pretrial ruling on other acts evidence between you and this witness. And I've been very, very careful to make sure that doesn't come in. But if you keep questioning her about whether she's afraid or not, or
I
why
didn't
she wouldn't
question her
have
about that.
contact or
I
not,
didn't
you are
question her about
opening
that.
the door to that testimony. All of
How-
my
how
rulings
does-
have
how
been
does-
made to prevent
how
what
does
could be
this
seen
work?
as prejudicial evidence. The standard's not prejudicial. The standard's whether it's unfairly prejudicial.
It's
But
unfairly
you can
prejudicial.
open the door
Your
to
Honor,
that,
It's
sir.
unfairly prejudicial that I have a document stating that November 20th never even happened, but yet and still the
Then
witness can get
have
on
you
the
turned
stand
that
and lie on the
document
stand.
over to the state?
Come on, man. Y'all know that's not right.
It-
Y'all know that's not right.
Then you need to immediately turn it over to the state right now. It may become relevant, but no one has seen it. When
So-
did you receive the
so that's
document?
what-
So hold on. When did you?
Wait.
I'm having you make an offer. But when did you receive the
Okay,
document?
but that, I just want to state for the record, Your Honor, that's kind of biased because the State did the same thing yesterday with creating an exhibit right on the fly that didn't even exist that I didn't have. But
That's
then,
not true, that's a
no,
misstatement of the
that
evidence.
is true.
No,
She said it herself.
no, marking an exhibit is not creating an
No,
exhibit.
not marking the exhibit. She said
We're
that
not gonna go
essentially-
down a tangent, sir.
All right,
I'm gonna
I'm not gonna
focus
argue
on
with
this
you,
and I'm
but
gonna
it's
give
not
you the
fair.
opportunity
It's
to
not
make
fair.
a record.
It's not
Right.
fair. It's not fair.
When did you receive this document that you claim was sent by this witness?
It is not claim. It's for a fact.
Sir, it hasn't been established yet. I need to make a
So
record.
do y'all want
I
the
wanna
letter?
see
Y'all
the
want the
letter.
email? What?
I wanna see the letter.
Okay, so I gotta.
And I wanna know
gotta
when you
bring that in.
received it.
I gotta bring that in. Every time, this is what I don't get. Every time I'm presenting something that needs to be made for the record and placed in the evidence, it's a problem. But the state can do it, no problem.
It's not, sir, there are proper procedures and I
Okay,
want
well,
you to
that
make
was the
a
proper
record.
procedure.
If you don't make a record,
So
then
what?
I can't make a
It threw
ruling.
people off the loop. They weren't ready for it. They scared of it. That's what it is. Come on, man.
Mr. Brooks.
Come on, man. Stop.
When you
Stop
are,
it.
you aren't
Stop
even
it.
letting
You're a
me
public
ask the
servant, Your Honor.
questions.
I respect your courtroom. I
You
respect you. You're a public servant, though. Your job is to be the referee. Is it or is it not? You stated so yourself on record that your job is being the umpire.
Your Honor, I asked Ms. Patterson to be excused.
Yes, you can be excused. My apologies.
My apologies, too, but it needs to be some truth. Especially when we're talking about stuff that didn't even happen, but they're allowed to get on the stand and say that it happened when they know it didn't happen.
So I'm gonna make a record about what
This
he's
is
referring
ridiculous,
to in
man.
count 77. Okay, the
And what happened to that paper? Because it was on the table. Then when I
Mr.
come
Brooks,
back in,
I
it's
need to
nowhere
make a
be found.
record of a variety of
So who
things.
took my paper?
And you keep interrupting me repeatedly today. I have shown an abundance of patience this morning. I've warned you repeatedly about being removed from the courtroom. And then every time I try to get into it, you, meaning an explanation and make a record, you interrupt, you attempt to divert everyone from what is being done this very second.
I didn't attempt to do anything.
Yes, you do it repeatedly, sir.
Whatever.
So you're doing it once again.
Whatever. Just make your record.
The document that Mr. Brooks wanted to show Detective Guth and this witness was a letter sent from the state of Wisconsin to the court regarding count 77. The state sought to dismiss that count and they have prosecutorial discretion, and I granted the request that the charge be dismissed.
Why was the charge dismissed?
And that's, I can't answer, it was dismissed because the request was made, sir. They don't need a reason. There's an abundance of case law about prosecutorial discretion. And they chose not to pursue that. My
Your Honor,
guess
Your Honor,
is maybe
with
to
all respect.
simplify things and to keep this tidy. I don't know. You know what? I'll indulge you. Attorney Opper, would you like to provide a basis for why the state sought dismissal of that charge prior to the start of this trial?
Yes, Your Honor, because as Ms. Patterson just testified a short while ago, she did not have any visible marks or injuries from that event. And we did have the photographs of her injuries. We did not want to confuse the record as to whether or not there was a battery that occurred on November 20th.
Your Honor, I object to that. What does the letter read?
You have the letter. You showed it to
I
me, sir.
tried. Yeah, and I've been trying to find it ever since I came back in, and now all of a sudden I can't.
And now
find it.
you're impugning, though, like somehow you're impugning the integrity of this court,
No,
of
I'm
the
not.
bailiffs of this state. You're accusing, frankly, everyone
Did I
of
point
moving
the
your
finger?
papers.
Did I point the finger at anyone? Did I say anyone did anything?
Not directly, but indirectly you did,
So
sir.
how can you make the assumption
made-
that I'm saying?
Can
that
I
I'm
please
pointing to
make the
someone?
record without
Yes,
you interrupting
yes, you may.
me?
Yes, you may. I apologize.
I appreciate that, thank you. But you made repeated comments, sir, about I can't find my documents, I don't know what happened, things of that nature. When you came back out, you took multiple minutes before you even asked your first question of Ms. Patterson. And if I need to, I'll have a bailiff put on the record that no one touched your table.
Your Honor, did I say anyone touched my table? I didn't say
You implied it, sir.
But did I say that? I
You
never
stated
said.
it implicitly.
I never asked the bailiff, hey, did any one of you touch my table? I never said that to them. I just said I can't find my paper, which is the truth.
And the
I'm
way
looking
that
now.
you said it, like,
I didn't point anyone
with
out
with,
though.
and like,
I
well,
don't
that's
think that
kind
that's
of
fair.
interesting.
I
I
don't
don't
think that
have a
that's fair to
document
the
that was
son.
just on my table. That is what you said.
That's
Words
what
to
I
that
said,
effect.
but I did not point the finger at anyone.
So,
I can
you
see
have
if
the
I
letter.
came in, Your Honor, with
You've
all
been
respect,
given,
I can see if I came in and said, hey, one of you moved something off my table, or if I would have directed that towards the state, or if I directed that towards the clerks or something like that, then that would be more of a validity to what you're saying.
I need to continue with the record, sir. It's very apparent to me, sir, that every time, I can't say every time because that would be an absolute, but many times throughout this trial, and especially the last 2 days, when the court makes a ruling that you disagree with, or I want to make a record about some behavior of yours, or a further record about a ruling that you, that was not in your favor, that you start peppering me with questions or comments, statements. You question me about the law. You ask, is it verified law? It is, from my perspective, a clear attempt to kind of turn us in a direction away from what we're doing, perhaps even to stall and to delay.
I'm sorry
That's
you
my
feel that way.
perspective. I'm making a rule. You're doing it again.
I mean, because it has no validity.
So, I am trying to make a record outside the presence of the jury about a line of questioning you want to ask Ms. Patterson. Now, I've reviewed repeatedly up on the bench 90608 and 90616, which are two of the primary ways you can attack credibility. I've referenced one of those previously. 90608 is evidence of character and conduct of a witness. I'm not going to read through it all, but it's limited to character for truthfulness or untruthfulness. It's not specific instances of conduct. It's character evidence, which frankly wouldn't even come from the witness who's testifying. All right, then there's the statute on bias, 90616. All right, and none of the questions as I heard them went to a permissible topic under bias of witnesses. You generally said credibility. You did not give me any further explanation as to why you believed it was relevant to credibility. Now we have you claiming that there's some document that was sent by the witness after the charges were filed that apparently contained photographs. And you can clarify the record momentarily when I'm done, that you believe goes to the credibility of this witness. So I need to ask a few questions about that, sir, to determine whether it has relevance to those issues. Number one, when did you receive this letter?
I received this multiple letters actually over a period of time. It wasn't. I referred to this one because this one had the pictures, but
And why do you
the
believe
one
it was from
to
Ms.
answer your
Patterson?
question, to answer your question with clarity,
Thank you. Does it have a date on it? The letter?
no, I didn't bring the letter. I brought the pictures because I thought, from my interpretation, I thought showing the pictures would be okay. How did I get these? So my mind was saying, show the pictures. They didn't come out of thin air. The witness
We need the
knows that
letter.
they sent me the pictures. They know that.
Well, again, it assumes facts that aren't here. You're assuming this witness sent it. I don't know. But even if she did, what relevance does it have to her credibility before this jury?
It goes to the credibility because she's put on this facade of being so afraid of someone, but yet still, you know that we're not supposed to have contact, but you still sneaking behind and saying, oh, I wonder how you're doing, and oh, this and this and that. Oh,
I don't think
no, I
she's
still
ever
love
said
you.
she was
Oh,
afraid. I think that was the officers who may have stated that. But I don't believe she
But-
ever said that. She specifically said today when you asked her why did you, it was either why did you go back or why did you have a look at my note? And she
It was
said,
why
I don't know.
it was why weren't you forthright with all the details? That was the question.
So again, I'm gonna ask you, even if this letter's from her, these pictures are from her, how does it
Your
relate
Honor.
to her credibility before the jury?
Who else could these pictures be from?
I'm gonna ask you point blank, did you get a letter that's signed from her?
I got. What do you mean sign? No
How
one
do you
signs
know,
letters.
what's your belief, why do you have a belief that they are from her?
I have multiple letters from her.
You're not answering my question. Why do you believe the letters are from Erica Patterson?
Because they were sent from Erica Patterson. Why else would I?
Were they signed by her?
What do you mean sign?
Did she write her name on the letter? Was
Are
it the
you-
content
are you
of the
kidding
letter?
me?
No, I'm not kidding you. I need to make a record, sir. You're making a statement that these letters are from her and that they're relevant to her credibility.
Your Honor, I'm gonna go out on the limb here.
And I'm asking you why you hold that opinion.
I'm gonna go out on the limb here and assume, which I know is true, you've never been in my position. You've never been in jail. So you've never received a letter from someone writing someone in jail. No one is gonna when you
You're
say
not
to me,
answering my
when you say
question,
to me,
sir. What's the basis why you believe they're from Miss Patterson? Is there some information in them that only she would know? Did she sign the letters? Is it penmanship that you recognize? Why do you believe they're from her as opposed to somebody else sending you information? Could be your mom, could be, I'm just saying,
why
could be
was
anybody
somebody-
else.
This is-
You gotta answer my question. It's
Your
called an
Honor,
offer of
this-
proof.
But you still gotta understand why this is mind-boggling to me. Like how I got a child with this woman. Why would I not know her handwriting?
But you have to
Why
lay
would
a
I not know?
foundation for these letters, sir. That might be
This
through
is
your own
ridiculous.
testimony. So that I'm trying to figure out why you believe they're from her. Not all this other stuff
Are
about
you
I'm in
serious?
jail and I have a child. I'm trying to I need to know. It's called an offer of proof.
Are you serious?
What do you believe? Why do you believe they're from her? I am serious. I need you to
Because
answer.
they're from her.
But you're assuming
Like
that.
how else am I supposed to answer that?
I've given you a few reasons why it would lend to that opinion.
So it has to be put in a legal
The
term.
bottom
or
line is I
something?
need the letter. So if you're gonna question her on that, the state absolutely has a right to see the letter. So you need to provide that letter. The bottom line is I'm not gonna allow any questioning without having that letter.
So
The
what
state
about-
has the ability to question you about that, or question this witness, and to look at the veracity of what your claims are here. So, I may take an early lunch. If that's in your cell, then you can go get it and bring it. But without that letter, I'm not allowing this line of questioning.
Please like and subscribe.